brother sells property to his sister, or estate planning is done, and those transactions don't represent any market value, or property is leveraged, okay, for another transaction, and those are disqualified. So we don't use those in the mix. Doesn't mean that we don't know about them. We receive them. They go through the same sales qualification process as any other transaction. But when we get down to the transactions that actually represent arm's length that we can use to determine market prices, that's the information that we use to determine that year's values. Any questions there? Okay. Not working anymore. It's a trick. Post-Halloween. See if I can go backwards. Nope. So what happened was, so while they're figuring it out, let's talk about something that's kind of timely, Amendments 5 and 6. So I'm not asking you how you vote. I'm just going to tell you about 5 and 6 because those are two amendments that property appraisers around the state are both supportive of. One is an amendment to increase the time of portability from 5 years to, from 2 years to 3 years. I believe that's Amendment 5, unless I have those backwards. So we are supportive of that. That gives our property owners time to make that transition without losing their portability. Right now it's currently 2 years. So this has been an initiative that's been in the legislature a couple of years, and it looks like that we may get that passed. So we are supportive of that. We find that a lot of folks get caught up in doing owner-builder. So they're owner-builder and they're kind of building as they go, pay as they go type of thing, and that increases, gives them another 12 months to complete that. Sometimes folks leave Brevard County and they realize they've made a mistake, right? We get them back. So if that happens, they have 3 years for that portability to be able to take that previous differential from their old property to their new property. So we are definitely supportive of that. The other one is near and dear to my heart. We currently have one veteran exemption that does not contain survivor benefits. We like to think of this as a cleanup bill, or in terms of a glitch bill that would clean up and make sure that those combat-related disabled veterans, that their surviving spouses receive that. Is it working now? Okay. So we are supportive of that as well. We hope that we will see affirmative on both of those amendments. Nope. Yep, it's working. Okay, so here's some more statistics for you. Got a column here, year built, number of units, and percentage change year over. It's about I don't know, I got 5 or 6 years up there. I always start with the end of the crash because there's a lot of us that remembers that. We lived through that. So for 2019, we had about 2,279 new units. These are single-family residences, townhomes, and half duplex that we classify as an SFR. We saw just a slight reduction, about 7% reduction based on what was built in 18. Still a very, very healthy new construction market for residential. You guys are nodding. You're like, yep, that happened. So if you've ever heard me speak, you'll never hear me speak without bringing this slide, which is basically a pictorial of the bubble. We all lived it. We all recognized it. We've since learned a lot of the factors that contributed to that, AKA when real estate prices are increasing year over at 43% and CPI is at 2.7, that won't reconcile, right? And we kind of live through that. So I like to keep this. The other thing that this slide does is it gives you a good picture of the trend. So the red line there is a trend, and we've done a trend analysis of taxable value basically over the 20-year period. Kind of basically tells you the depreciation for taxable values in Brevard County in the aggregate, so we're talking the whole polygon there, is about 4 to 5%. So that's about how much you can see taxable values appreciate year over in the aggregate for Brevard County. So that's what that red trend line exists. You can see the self-correction of the market, and now you can start to see the increase in differential. So that difference between market prices and assessed values, meaning that a lot of those folks are claiming homestead exemption, and we're now seeing that differential grow, that difference between the market and assessed. Remember, when the market dropped below, when market values and sale prices dropped below what taxable values were and assessed values, those reset. Everybody lost all of that differential. We were kind of back to a basic homestead exemption, which, by the way, made my life very easy when it was just one homestead exemption and it applied to all tax rates and everybody saved about $500. That's not the case anymore. But we did see a self-correction of the market during that period of time. Any questions there? Just some more pretty graphs. This is new construction counts by market area. You can kind of see what those market areas there. Vieira Suntree, okay, typically been the winner for the last few years. Palm Bay and Melbourne, giving everybody a run for their money. Okay, sales qualification letters. We get a lot of questions on those because we now have to send out questionnaires whenever there's a property that transacts. So how many of us use lots of hair color and remember when a DR-219 used to be used every time you transacted a real estate transaction? Do you remember those? Anybody remember DR-219s? Okay. Well, years ago, whenever you made a transaction and you filed a copy of a deed, a DR-219, an affidavit had to be filed at that time. And basically what this affidavit did is it told the state and the property appraiser the conditions of the sale. And it gave us information to tell us, hey, this may not be arm's length. So you would disclose things on this affidavit that would say, this is atypical financing, this property wasn't marketed, or I sold my property to my brother. And we would know from the affidavit that we could just disqualify those sales, okay? Foreclosure sale, post-foreclosure sale, those types of things. Well, the legislature, in their infinite wisdom, because there are some bright forces up there, right, decided that this was no longer needed. And so now, when every transaction comes in, the property appraiser sends out a questionnaire to buyers and sellers saying, hey, can you tell us a little bit about this transaction? And as you can imagine, anytime the government sends you something, the first question is, do I really have to do this? And the answer is no, it's not required by law. And the second is, why should I do this? Okay, so we get lots of calls on there, and you know, we try to let folks know that this is just information we're trying to glean to determine whether or not this is an arm's length transaction and whether or not we should consider this when determining market prices and market rates for the following year. So some of you may like not having to fill out that affidavit. I can tell you that it requires that the property appraiser now do the work that replaces that affidavit. So not a fan of that. And nobody called for my vote. Lots of exemptions. Most of you guys are aware of these. You would be surprised at the number of folks that live in our county that have been living in our county for years. It's their primary residence and they've never filed homestead exemption. And I can tell you, whenever these folks do call us or come in or file online and we see that they purchased their property, 8 years ago, but they've been living here, it hurts our hearts because we can't do anything retroactively. So we are constantly trying to get information out there about various exemptions, particularly our veterans, because we have a myriad of veteran exemptions. All of them are related to disability. So there's no exemption for just being a veteran other than a combat veteran when you're in combat. We do have those types of veterans when you're actually away. And we'll talk a little bit about that. But we do a lot of outreach. We're going to be beefing that up actually next year, and then we're going to be doing more outreach, and we're going to be using some more tools and some more digital media to get that information out there. We're going to be getting a little bit closer, trying to beef up our relationships with our title agents and our real estate attorneys and folks that do closings to make sure that this information is being passed on to your potential buyers. Assessment caps. We all know that there are assessment caps in Florida. So it gets a little bit confusing, probably not too much for folks in this room, but it does get confusing for some of our property owners, particularly that are new to Florida. But we basically have two assessment caps. One is a 10% cap for non-homesteaded property year over. Okay, if there's no change in the title, they get the benefit of a 10% cap. So market goes up, whatever market goes up, assessed value can only go up 10%. For those properties that have homestead exemption, that index is 3% or the CPI, whichever is less. So again, changes in title can affect that. Please let your customers know whenever they make a change on the title of their property, particularly those doing estate planning, just reach out to us. We're not officers of the court. We don't practice law. We don't do estate planning. But we can tell folks if they're making a change to their title, number one, if it affects the benefit that they receive, and two, whether or not that requires a new application for homestead exemption, which in most cases, the answer to the latter is yes. The answer to the first question depends on what type of change is made, and I'll give you an example. Brian and Dana own a property as husband and wife, tenancy by the entireties, and we put the property into a trust. So we create the Brian and Dana Blickley Revocable Trust, and we fund the property into the trust, meaning that we deed it into the trust. That would require that we file a new application for homestead exemption, but it does not remove the cap. So if we'd had homestead exemption for several years and we had the benefit of that, that type of change to the title would not affect the amount of homestead exemption or our differential, our cap. Conversely, if Brian and Dana decide that we really like Tammy Watts and we're just going to put her on the property as a tenants in common, now we've got a 50% ownership and she's got a 50% ownership. It's going to affect both the amount of exemption that we're receiving and we're going to have to file a new application. We love Tammy, but we're not doing it. Now, conversely, if we put her onto the title as joint tenants with rights of survivorship, we'd refile our exemption so the property appraiser knows who lives there. Because if you add Tammy on, we don't know if, number one, does Tammy live there and Brian and Dana don't now? Or two, did Brian substitute Tammy for Dana? Or three, is that just an estate planning mechanism and we still are going to have a benefit there for Brian and Dana, but Tammy is now on the property as joint tenants with rights of survivorship. So if Brian and Dana take an exquisite vacation and somehow don't make it back, Tammy ends up with the property and avoids probate. So just some examples of title changes, very, very important if you're assisting folks with those that they understand how that may or may not affect their title and or their benefits that they receive. Talked about the 10% cap. Portability. Does everybody in here understand portability? Because if you do, I won't go too far in depth. And it's okay if you don't, because it gets a little hairy. So basically, portability is just bringing that savings, that differential between your market and your assessed to your new property. Okay? We talked about that on an amendment, I believe it's Amendment 5, that would take that time period from 2 to 3 years. However, where this can get a little hairy is when you're going from a higher price property to a lower price property. So if you're going from a lower to a higher, you're moving on up, you take it all with you. But if you are actually going from a higher price property to a lower price property, then you only take a portion of that with you. So here's the math formula for if you are porting up. We talked about it first, where you're taking all of your differential with you. See how I'm pointing, and I think the pointer works and it doesn't. And this would be a simple sample math equation if you were porting down. So you would only take a portion of that differential between your market and assessed. So we have this sample on our website, so you can just kind of point somebody to it or print it out if you're helping somebody and they want to know how it might affect their benefit if they're kind of scaling down. Would give them the formula to be able to figure out what their assessed value would be on the new property. Calamity. Here's the one thing I want to say about calamity. There is a law that allows folks to rebuild their properties without being penalized and being taxed as new construction if they're affected by a named storm or something that would qualify as calamity. Here's what I want to tell you, and I see it every month. A lot of builders and contractors, and I'm by no means passing judgment on what their process is, but if somebody, say, has a fire or has a property that's damaged by a named storm, and they're going to hire a contractor to rebuild the property, a lot of times the builders will require that they deed the property over to them for the period of time when they're building as the collateral, and then the builder deeds the property back. Florida doesn't recognize that as anything but a change in the title, and they lose their homestead and they lose their cap. I talk about this everywhere I go, especially to folks like you. Again, I'm not passing judgment on their process, and I understand why they are requiring the transfer, but it eliminates all protection for the owner. So something to keep in mind. Estimating taxes, your favorite topic. So we're going to talk a little bit about this. First and foremost, the trim notices that we send out, that my office sends out in August, does not include the non-ad valorem assessments. The reason why is because, first of all, the non-ad valorem assessments and their rolls are not due to the collector until September the 15th. Okay, so a lot of them haven't even had their final meetings and even adopted what their final rates are going to be for me even to provide that information. If they were to do that, which I doubt they ever will, because that would be changing their entire roll process and their timing and their public meetings and their advertising and all of that, pretty much all of them would have to choose to do that. And you know, in Brevard County, there are lots of non-ad valorem assessments throughout the county. So it would be very, very confusing if, you know, say 3 of them got their rolls done, and I put that on the trim notice, but it only represented 15% of what folks were going to pay because the other 7 agencies they pay weren't done. I think that would be a disservice. So, you know, I've been in this business almost 33 years. I started when I was 12. And I don't ever see that changing in terms of the non-ad valorems being on the trim notices. It's a big complaint for some of our property owners because you guys know that some of the non-ad valorems can be pretty hefty. CDD fees, some of the other commercial rates for services can be pretty large, particularly on commercial properties, but it's probably something we're never going to remedy simply because of the timing of those rolls. So what we always try to tell folks is make sure that you look at what those applicable rates were last year, because those are service fees. That doesn't have anything to do with the value of the property or the levies that are being adopted by elected officials every year. That's a pretty known element as far as what to expect on those fees. So we always tell folks, make sure you look and see what those non-assessments were the previous year. Any questions on those? Okay. So in this case, I'm not going to go through too much of this because you guys are pretty experts in this field. But what we do here is try to help people understand how to do a very simple tax estimate for a new buyer. And here's the rule that we tell folks to live by, and you'll never go wrong. If you simply use the sale price, okay, and subtract homestead exemption only if it's going to be their primary residence, do not subtract it, of course, if it's not, and apply last year's tax rate, you're going to have a figure that they're not going to exceed, that you're not going to see a tax bill that's higher than that, okay? That is the safest thing to do. Use 85% of that purchase price, apply it to last year's levy, apply the homestead exemption if it is going to be the primary, and leave it at that. Now, in some cases, you're going to have overestimated because there may be portability that is going to be there. But then you've got, if you want to do that exercise, you've got to figure out what that differential is from the previous property, and if it was out of the Brevard jurisdiction, you've got to go to the other jurisdiction. Now, we do this every year. That's what we have to do for every property that files. But for you to do the estimating, that's quite a process. Plus, sometimes folks, and I'm not saying that they're not being honest, but sometimes folks don't understand certain types of exemptions, particularly disability exemptions. Some can be $5,000, some can be a total and permanent where they pay no ad valorem taxes. Okay, and sometimes those percentages change, and the T&P can change. So someone that may have qualified for an exemption, particularly if it's a civilian, may not still have that exemption if it wasn't a total and permanent. So I would caution you not to get into that field because they're going to do to you just what they do to us. If we provide an estimate and we don't have all the correct information and all the pieces and parts that make up that actual tax liability, they're going to be, wait, you said I was going to be paying $2,300 and I just got a tax bill for $4,700. So this is the safest way to give folks a pretty accurate figure that is going to be one that is not going to exceed what they're going to see the following November. Anybody have any questions on this? And this is just an explanation of how to do that, to take 85% of the purchase price, apply the exemption. Remember, depending upon the value of the property, it may not get the full 25 or it may not get the full 50, depending upon the value. No questions? What else is timely? One of the things I also want to talk to you about just a little bit is what we call homestead fraud that is non-intentional, okay? And I think I've spoken to you guys before because I've been working on some legislation. I've got it through the House twice. Can't seem to get it through the Senate. I'm going to be back up there beating on the senators' doors this year, and it goes something like this. In the state of Florida, you can only receive one residency-based exemption. We call that homestead exemption. It's pretty self-explanatory. I'm going to exempt my homesteaded property. In other states, they're not always called homestead exemption. In many states, they don't represent the amount of savings that they do in Florida, particularly because they may be a state that doesn't have an assessment cap, or they may be a state where their homestead exemption isn't called homestead exemption and saves very little money at the end of the equation there when they get their tax bill. Some of them are called circuit breakers. Many of them are not specified on the tax bill the way that you see our exemption. So when you get a tax bill in Brevard County or basically anywhere in Florida, it pretty well lists out all of your exemptions and will show you what exemptions apply to what levies. Your trim notice does that as well. In other states, that isn't the case, and you may just have a couple of letters. It may see OC or CB or circuit breaker, and it may save folks $8 a year. But it is legally classified as a residency-based exemption. And if we find, when we sometimes do an audit, that folks are receiving a benefit in another state, when we find that out, the law as it reads today says the property appraiser shall remove the exemption, shall remove the assessment cap, and shall lien the property back to up to including 10 years. So what that means is if somebody's receiving an $8 benefit in another state and we find that here, it could be a $25,000 bill for them. Okay? To make matters worse, we have had cases where when folks applied for their exemption, and I use that word applied, they applied at closing. So it's not an actual comprehensive process like we do here where we ask you for your driver's license and your vehicle registration and your voter's card and the date of birth of your firstborn and prick your finger, right? They don't do that there. A lot of that times this is done at closing where they're just checking a box. Is this going to be the primary residence, yes or no? So if a clerk makes a mistake and checks the wrong box and that's processed and somebody's receiving an $8 reduction in their property, they don't realize it. It's not like a big, huge savings where you don't get a homestead exemption and not realize it in Florida, right? It's a pretty big difference in your taxable value and in your tax bill. But if you're saving $8 and you declared, no, this isn't going to be my primary residence, and I catch you, I have to lien you. Even if you didn't apply for it, and even if the jurisdiction writes a letter that says, hey, property appraiser in Brevard County, this was a clerical error on our part, they never told us this was going to be their primary residence and they've never lived here. Still, as the law reads today, I have no statutory authority to do anything but to lien our good bona fide Florida property owners. And I am vehemently against that. I have been trying to get a bill passed that says if the property appraiser by evidence can show that they did not make application, that the Florida owner did not make an application, and they provide that to us, that we can keep their information intact, and they just remove the exemption there, and we keep their information intact. So I may be asking for your help as I go around again. I thought last year was going to be a great year to get that done. We certainly had a great climate for it until the Senate shut it down. So it wasn't that this bill wasn't popular, it's that it died with a lot of other great bills up there in the Senate. You guys are shaking your heads. You may have had some good legislation up there as well. Yes, ma'am. So a couple of ways. The first way is that about every 5 years I do an audit of all homestead exemptions, and we actually farm that audit out. We hire a vendor. It was TMA that did our last audit. It's the first one that we've had. And what they do is they do a very large data mining exercise where they have databases, LexisNexis, those types of things, where they have all of this information. So what they do is they take our homestead roll and they compare it, and they data mine, and they say, oh, Tammy Watts owns property in New York and has a star exemption in New York, and she owns property here in Brevard County and has a homestead exemption. And they give that over to us and say, this may be a case of fraud. And then we do the investigation, okay? It might be as simple as, and this would be more in the intentional cases rather than non-intentional, it may be that Dana's been putting her palm fronds over on this gentleman's yard instead of her own, and he's ticked, okay? So he also knows that Dana Blickley is the tenant, not the owner, and he can see right on our website that there's homestead exemption. So sometimes we get those calls. Oh, by the way, Dana's over here putting these palm fronds on my property. We tell them, well, you have to call code enforcement for that. Oh, yeah, well, they've got homestead exemption and Dana's the tenant. So that's a very small percentage, probably less than 2% are those types of calls, but trust me, we get them. And then the biggest way that we find intentional cases are address changes, because folks want to get their mail. So they have homestead exemption and they change their address, and we get that information, and then mail comes back to us, and we investigate it and end up taking action on those cases. So those would be the top 3 ways that we find that information. On the out of states for the non-intentionals, that's typically through an audit. So what I tell folks is, if you think that you might be one of those folks, don't call me, okay? Go to the jurisdiction that you're not living, that you're not a bona fide resident of, and have that exemption removed so it doesn't catch you up here until I can get that law changed. Got to be other questions. Yes, sir. Okay. Confused? Yes, well, the legislature made that process very confused, so you're not alone. Did everybody understand his question? He was asking, when he's looking at properties, he sees a non-school and a school taxable value, and he sees that some of those values are higher, like the general fund values. They're going to have an exemption that applies to the general fund that's not going to apply to school, and he wants to know, why are those values different? Correct? That's your question. The reason that those values are different is because there are some exemptions that do not apply to some levies. So the first $25,000 applies to every taxing district. So when you have homestead exemption, the $25,000 applies to every levy, including school. The second $25,000, or a portion thereof, depending on the value of the property, only applies to non-school. So one apply to voted debt, one apply to non-school. okay? And then some other exemptions and assessment caps work that same way. They're not applicable to school. So basically what it says is school board's going to get their money, right? Because some of those exemptions don't apply to them. So that's why your trim notice and also your tax bill is going to have that taxable value and that levy and that, the millage and that final value is going to be listed for every taxing district for that property, because it can be different, and it will be different, particularly if there's an assessment cap or a homestead exemption there. Mm-hmm. What's your first name? What's your first name? Yes. Well, somebody must not like you. I mean, that must be the answer, right? I'm kidding you. So his question is, I'm looking at a similar price property, and I'm looking at a difference in a sale price. Why am I paying more taxes than my neighbor? So I don't know the exact properties, but I will give you a general answer. So the first thing is the market values, if they are the same exact properties, shouldn't be different. So if you've got a 1,500 square foot house and you've got a 85 by 125 lot that it's on, and both have a swimming pool and both were built the same year and both have the same quality construction, you shouldn't see a difference in the market value. So if you do, you need to talk to me after this meeting. However, the taxable values can be much different. So we're going to take those two exact, we're going to use a cookie cutter neighborhood because that's easy, right? Where you've definitely got the two of the same builder, same quality construction, same year built, same amenities, okay? And you've got a difference in taxable value. Well, if one was homesteaded, right, in 2010, okay, and now you just buy the property next door to it, you are going to have grossly different tax bills because the person that owned the house next to you had several years worth of homestead exemption and enjoyed that assessment cap. So that assessed value was being capped while the market value continued to go up. So market value's here, assessed value's here. On the house that's next door, their market and assessed the first year is the same. So they don't have any of that protection. It's all right here until they apply for homestead exemption and then cap that assessed value. Probably the number one question we get, other than what do I need to bring to file for homestead, is that exact question. I'm looking at the taxes on a property that I'm getting ready to buy or that I've just purchased, and I don't understand why my tax bill is so much higher than my neighbor. It's the same exact house. Or he's got a pool and I don't have a pool. That is correct. But he has 10 years worth of assessment cap protection that you don't have as a new property owner. That's the answer, but I'll be happy to take a look at the two particular properties and see what we see. Yes, ma'am. So the answer to your question is yes, that was an example that I gave to give you a concrete example of what would require a new application and what changes may be affected as a result of that type of change. But to answer the general question, yes. I would highly suggest that particularly older property owners, that they do some type of estate planning to avoid probate, right? Because last thing we want to do, particularly for those folks that their estate is generally going to be, for most of us, a few bank accounts, some automobiles, and our home, okay, or maybe another property. That would probably describe 2 standard deviations under the bell curve of most of us, right? Yes, I would say to those folks, make sure that you reach out to proper folks, albeit attorneys, or estate planning folks, and make sure that you've done whatever you need to do to ensure that among your demise that you don't have a property where you have to pay to have it probated. And there's a myriad of ways to do that. So there's trusts, there's adding people to the title as joint tenants with rights for survivorship. All have different benefits. Some have different federal income tax benefits than others. Trusts, of course, provide other types of protections. So I'm not making a suggestion here to do one or the other, but I'm absolutely making a suggestion, particularly to older property owners, for them to make sure that they've done whatever it is that they're wanting to do to ensure that they have estate planning in place to where somebody's not having to pay attorneys. So if I have any estate planning attorneys, sorry, just to take care of maybe, a single-family residence or what have you. So trusts are great. I have a trust, and that's one of the ways that you can design your trust. So the trust owns the property, but you have the right while you're alive to live on the property and claim homestead exemption, and that's an important part of the trust mechanism that needs to be in place to ensure that, because there are some folks that have trusts that don't allow them to actually reside on the property and have homestead exemption. So we do have some sample language that must be contained in there. We have very few problems with that. Most of our estate planning attorneys know that and do a pretty good job of that. And a lot of times if they're new in that area of estate planning or trust management, they'll reach out to us and we'll tell them, what has to be included in there. But yes, everyone should make sure that, really any age, that we have proper estate planning, that our titles are such that, there are properties going to be disposed of at how we choose without having to include the court system. Expensive. Yes, ma'am. Great question. It's automatic. So there's nothing that the homeowner has to do to receive a portion or all of the second $25,000. That's based on assessed value, period. So if you have an assessed value of $75,000 or more, you're going to get the full 50. If it's less than 75, you're going to get the first 25, then a portion thereof depending upon the value. Good question. Yes, ma'am. So that's a legal question. So I'm going to answer it this way. As I am not an officer of the court and I do not practice law, I can tell you with Dana Blickley's trust and her remainder men, no, there's nothing. Everything is set up to pass to the folks that are supposed to receive my property through that trust and through my will. Now, obviously, deeds have to be done, personal representative deeds and those types of things, but it is set up to where it would not require the court to dispose of my property the way that I wish it to be disposed of. Yes, ma'am. Yeah. Did you guys hear her question about the Airbnb? So she's asking, how do you find out that she knows that she has some property owners that rent out their property? So they rent them out as Airbnbs, and she wanted to know if we find out about those, if we take action on those, and how are we finding out? Is that when they're claiming homestead exemption? So the answer to that question is yes, yes, and yes. So the first one is yes, we are finding them every day. that folks have homestead exemption and they rent their property out more than 30 days for 2 consecutive years. We find that all day long. How do we find out? Well, the first thing is they advertise it. Okay, so if you want somebody to rent your property, you go out to Airbnb and you go, I have this beautiful home on a canal in Brevard County, rent me now. And also on that page is all of the great reviews where Leah came and rented it for a month and Tammy came. And man, we can tell exactly how well you're doing as an Airbnb on that site. So yes, we find many of them that way through them advertising. We also find out when Tammy comes and throws a party with all her crazy friends that the neighbor's not too happy about that Airbnb. Everybody knows about Airbnb and NIMBY, right? I don't like those Airbnbs in my backyard, so they pick up the phone and call the property appraiser and say that this person is getting homestead exemption and they rent their property out continuously. So those are the 2 big ways that we find those. They're not hard to find. I have had and am having court cases on them where folks still believe they should be able to rent out their property and receive homestead exemption. I'm happy to tell you as taxpayers, you're winning those cases. I'm unhappy to tell you as taxpayers, we're having to pay for those cases as taxpayers. I can tell you when they're egregious, I file something that requires that they pay their attorney fees and ours because I don't think the taxpayer should have to foot that bill. But we have them every day. Every day. Yes, sir. The Supreme Court has just spoke on that. Actually, I take that back. The appellate court has just spoke on that, and it's being taken to the Supreme Court. And so far, the property owners have been successful in that if you rent out one room of your house, think about it in terms of a roommate. If you have a roommate in your house that pays you X amount of dollars to live there, that does not constitute that you've abandoned that property or that you do not qualify for homestead exemption. So as the law reads right now, the property appraiser cannot remove that exemption or should not remove that exemption simply because you're renting out a room. Now, if you go out on, we've got some active cases now, if you go out on Airbnb, and it can be kind of tricky. Let's say that you have a single-family residence that you rent out the top half. Okay, so it's got a bathroom up there, but doesn't have kitchen facilities. And I believe that one of the cases on the other side of the coast is kind of that situation. So far, the Sarasota property appraiser has been unsuccessful in that case. So I think it's probably going to go to the Supreme Court, but the property owner has been successful in saying, hey, that's not an abandonment of my homestead. It's still my primary residence, and I'm not renting out the entire property. But I would tell you, be careful. It's a big penalty, big. It's a 50% penalty and 15% per year up to 10 years. So I've had liens as high as $35,000. That's a big. So if you're in doubt, don't do it. That'd be number one. I would never tell somebody, I've got a huge libertarian streak in me. I'm going to do me and you do you. But if you're going to rent out your property, you better know, and have homestead exemption at the same time, you better know how many days you can rent that out and what portion of your property, because it gets real hairy. If you want to have an Airbnb, just don't file homestead exemption. That's the easy answer, right? That way you can have the benefit of the income and not worry about the penalty. What else is timely? Tax bills came out, right? So the tax roll, generally, Lisa will release the tax roll up to a week early. So tax bills are all out there online. They're just like a trim notice. Every tax bill can be accessed on the website and paid through the website. And of course, everybody, I think in this room knows if you pay your taxes in November, you get a 4% discount. In December, 3, January 2, February 1, March, full fare, April 1, taxes become delinquent. Yes, sir. The question is, a veteran can get up to 4 VA loans. I mean, correct. So he wants to know basically, can they have homestead on the entire thing? The answer is no. So it's just homestead exemption is no different for a veteran than it is for anybody else. The only thing I will tell you is veterans can rent out their homesteaded property with active orders without penalty. So we allow our veterans to do that. It's very specific in the law. And I'm also supportive of that. Yes, ma'am. No, you do get a hard copy of the tax bill. Yes, ma'am. So her question was, will I still get a hard copy in the mail of the tax bill? Just like a trim notice right now, you will still receive a hard copy. We see trends going in that direction, though, right, of eventually, probably at some point, maybe not before I retire, right, that we may not receive the traditional bill by snail mail, by regular USPS. There may be a point in time where we just receive them electronically. And I can foresee that. Not just because it's a cost savings, it's a huge cost savings. I can tell you that just to mail out the trim notices in August, that's about a $60,000 venture for taxpayers every year to mail those out. And unfortunately, a lot of people read on the front of it, this is not a bill, do not pay, because if we don't leave that on there, then they try to write us a check. Okay, so we tell folks it's not a bill, so you don't pay that. Unfortunately, a lot of folks take that piece of paper and they put it in file 13. And what's unfortunate about that is your appeal period. You have 25 precious days to look at that trim notice and either one, disagree with the value, disagree with the amount of exemptions. Maybe you've applied for an exemption or you've applied for something that you feel should be on there and it's not there. That's your time to reach out to the property appraiser and find out why you feel there's a discrepancy there. It's also your time, your appeal period to administratively appeal it. If you meet with the property appraiser and you still disagree, you can pay $15 and take that case to the Value Adjustment Board and plead your case there as to why you feel the property appraiser is incorrect, and you can miss that time period. The other thing it doesn't do is it eliminates your participation in the budget process, which I hope all of you in this room do. You need to, at a minimum, need to know when those budget meetings are, when they're being held, and weigh in on what's, being approved by way of either the levy that's going to be applied to the taxable value or those non-ad valorem services and charges. Very, very important piece of mail. Fortunately or unfortunately, the law is extremely specific on that notice and how I mail it, what is to be there, down to the font. It actually specifies in the Florida statutes what font that I have to produce that notice in. So I get very little discretion on that. No discretion on the time of year that I mail it to you, which is very timely. But it's a very, very specific notice. I just always wish people would actually open it up and read it, because they like to call us when the tax bill comes out, and then that's too late. It's too late for us to review information that we could have considered in making a change in valuation or making a change with an exemption, and they've also lost their right of appeal to where even if we still disagreed, where they could appeal that formally to the Value Adjustment Board. So please, please, please open that mail and take a look at it. I'd like to think that we're perfect and we never make mistakes. We're pretty good, but things can happen. So somebody else have their hand up? Yes, ma'am. Did you hear a question? She's asking about the tax deed process and how many years, and this is really a question for the tax collector, but I'll give you a cursory answer. So anytime you don't pay your taxes, you plural, Lisa will make sure they get paid, and she will do something called selling a tax certificate. So she'll put that property out there for bid, and folks will bid on that property, and they'll pay a little fee, and they'll pay your taxes, and they'll have a tax certificate. And then that tax certificate is quite an investment. So there's going to be a percentage rate that you're going to end up paying if you redeem that. That's going to be accrued. So the investor is accruing interest on that certificate. If that happens 2 years there's 2 years in a row, or 2 years, I shouldn't say in a row, of unpaid taxes, then a tax deed can be applied for, meaning that that property is going to be put on at auction. And then the clerk of court is going to step in and sell that property based on those tax certificates, and then the holders of those certificates are going to get their money redeemed. They're going to get certificates redeemed once the property sells. So I hear a lot of that from people. They think it's 3 years. I don't know why. I think it's that 85% thing, right? If I pay $100,000, my value should be 85. There's a lot of folks that think that with that 85%, and a lot of folks believe that it takes 3 years, and it doesn't. It's 2 years. I don't exactly know the percentage of paid taxes, but it's very, very high with the certificate process. I don't know if any of you guys participate in that, but it's an all online process. It's pretty sophisticated, and Lisa gets her money. So she ends up with very little unpaid taxes that are struck off then to the county. The county ends up with those certificates, but it's a pretty high rate, into the 90s, upper 90s. Don't pay it, she'll sell it for you. Yes, sir. Yes. Yes. So one of the certificate holders can apply for a tax deed sale. So it has to be, can't just be anybody. It has to be one of the certificate holders. Correct. It can just sit there and accrue. And then at such time the property sells, somebody's going to want their money. Right. Website. You guys still enjoying the website? It's always a WIP. I know you guys hated me and you had your Dana Voodoo dolls a few years ago when we changed it. We have recently won an international award for the website. It was a very, very comprehensive process in applying for that, and we were recognized by the International Association of Assessing Officers up in Canada for that website. And we also recently received a Excellence in Jurisdiction Award from the International Association of Assessing Officers, and basically that is a comprehensive process. It's about a 250-page submittal where we basically fillet ourselves to the International Association and tell them how we do what we do in every aspect of our job, how we value, how we handle appeals, how we handle customer service, how we handle our internet, how we handle our IT, how we handle our HR, all of that. And we were just recently recognized for that. So I want to tell you, not just because you hire me to manage the office, but we have some phenomenal folks working for us in the property appraiser's office that do an excellent job, and none of that would be possible without their efforts. They really are some incredible people. Our customer service staff is absolutely incredible, and they work tirelessly with sometimes folks that aren't real happy to come in. You know, we talk about property taxes. They're not real happy, and one of the things I'm very, very proud to say, you know, we kind of messed up a little bit with our Vietnam our veterans, right? We kind of messed that up. So a lot of times when they come in to interact with government, they're not very trusting of us, and unfortunately we've earned that. And I will tell you that we have such a positive response with how we deal with our veterans when they come in and conduct business with us. So not only is Brevard one of the veteran most friendliest places in the world. When I say the world, I mean the world. I mean not just in the state of Florida, but there's 68,000 veterans here, and veterans will tell you, particularly those in need of services, that they will come across 3 states to get to Brevard because they know if they get here, they're going to get the help and the resources we need. So if you're a veteran, thank you so much for your service, if there are any of us here in the room. And I just, anywhere I go, like to talk about how wonderful the community is of Brevard and how much we take care of our veterans, because we really do it best here. So, thank you. That it? You tired of me? Go vote. Yes. The question is, can our techies come back and really get into the nitty-gritty of our website? And absolutely, yes. Yep.
We'll get one more round of applause and thank Dana for coming again. We appreciate your time. We know you're busy. Tammy got it. That's going to conclude today. But before we all run off, I just want to see if we can get a round of, if any of our sponsors want to come up and say anything real quick. If anybody didn't get to meet any of the sponsors, again, we got Be Our Guest Marketing. Go ahead and please stand up. And Alley Simplified. If you'd like to say something. And Next Door Photography. Brightway Insurance. Majestic Title. But knows Shanna if she hasn't run off on us. And Brevard Inspection Team, Kelly Cox. I see there. So if anybody didn't get a chance to meet them, please introduce yourself real quick.
Well, hi, guys. I guess you can hear me better now. Annie Cortez from Ally Simplify. And just to answer a question, because one of the team members doesn't know what a transaction coordinator does, so I'm just going to do a quick response to that. So basically, we are focusing on what happens when you guys execute a contract all the way until closing and the post-closing of that contract. We assist with all timelines, with all documents, with appointments between you and your vendors and your clients. And also we do the pre-listing preparation as well, which is we assist on the listing agreement, documentation preparation, also if you need to coordinate any vendors with your sellers, and we're staying in constant communication. What we don't do is we do not do any type of negotiations. We don't get involved on the way you do business directly with your clients. We don't want to, by any means, affect that relationship because you are the ones that will be getting their referrals out of these customers. But what we do instead is we take care of them. We make sure we are an extended side of your team. That way they can feel they are taken care of while you're still doing and producing and procuring more clients. So I hope that answers your question a little bit. But yeah, basically that's what we do. We are part of your team, and we're just here to see you grow and create other how can I say it? Other spaces so you can, or the options so you can do something else, because it's not only focusing on your business, but you also have to leverage your time in other ways. But thank you so much. Have a great day.
You all heard me speak already, so I just kind of wanted to give one final reminder. I'd love for it to be with us, but even if it's not with us, be using professional photography, even on your commercial listings. It drives prices, so remember that. Lastly, just wanted to point out there's a business card. There's our pricing on there. On the back side, it says Zillow 3D Tours, $50. We're running a special on those through the end of the year for only $25. Tremendous value. But then lastly, this card right here, you can see on the front it says list with an agent who cares enough to use professional photography. That's for you to put in any sort of listing package that you have to promote yourself as an agent that uses professional photography. So there's a few around the room. There's more out there. If you want to grab those, feel free. But spacecoast.nextdoorphotos.com. Thank you very much.
I think most of you were here last time. Anybody not here? I'm Angel with Be Our Guest Marketing. We sell closing gifts. Was anybody not here when I first spoke? I can open it up and show you. Okay, so for $45, you get all of the gift cards, the gift certificates that are within that zip code where your buyer buys their new home. So please go on our website, beourguestmarketing.com. There's a flyer at your table. Check us out, register as a realtor, and if you have any questions, please give me a call. Thank you.
Hello, Kelly Cox, Brevard Inspection Team. As I said before, our family's been doing inspections here in Brevard for more than 17 years. Full service. We do our WDOs, we do 4 points, wind mitigations, we do well water quality testing, mold testing. So give us a call. If you have questions on wind mitigation changes, they always change 4 points, that sort of thing. Give us a call. We're happy to answer those questions. Yeah, Shannon.
All right. I think that's it, guys. Thank you for coming out, and everybody that's online live streaming, thanks for joining this morning.